recording.
Hi, this is Lisa Damonte from mylegal.com. It's Thursday, May 6th, and we are here in Washington, D.C. for the American Bar Association's second annual National Institute on Internal Corporate Investigations and Forum for In-House Counsel. With me this afternoon is Bob Cleary. Bob, thanks for joining me this afternoon.
My pleasure.
Bob is a partner at Proskauer Rose's New York office, and Bob is the co-chair of the Litigation and Dispute Resolution Department and head of the Corporate Defense and Investigations Group. Bob just completed participation in a panel with defense lawyers representing both individuals and corporations in investigations by the government. And Bob, it was quite interesting for us today because the first panel this morning was with state and federal regulators
And prosecutors.
And your panel was with the defense lawyers, and there seems to be quite a difference of opinion between the regulators and the defense lawyers as to whether or not there is in fact credit for cooperation, and then interpretation on what information is actually privileged.
Sure.
Can you share with us some thoughts about those discrepancies?
Certainly. The Department of Justice is very fond of saying, in an effort to get corporations to cooperate in criminal investigations, that they will get credit for cooperation, what's called cooperation credit. And at the end of the case, whatever the value of that cooperation is will be taken into account in the charging decision and if the charge is brought in the ultimate penalty. The problem with that, it's a wonderful concept. The problem with that is there is no empirical data to support the concept. So if a company cooperates and provides all sorts of information, some of which implicates the company itself, and at the end of that process gets prosecuted and fined, there's no way you can point to what the result would have been had they not cooperated. So it's a problematic concept. I also don't accept it in its entirety because I have seen many situations where it appears to me, and I think would appear to most objective observers, that after providing a tremendous amount of information that implicates the company, cooperating fully, the penalties that they get at the end of that process are substantial, quite substantial. And the other wrinkle to this that is problematic is when the government says you have to cooperate, tells a corporation it has to cooperate, that means 100%. It means not just on the facts that they're looking at, but typically they're going to ask the company to do their own investigation on other acts in maybe other jurisdictions. And what fairly frequently happens if a company is cooperating fully and accurately, they will find other misconduct in other jurisdictions that the government knew nothing about and could wind up getting prosecuted for that as well. So it's a very problematic concept.
So it's really expanding and opening that Pandora's box
That's
to
right.
things that may not have come to light.
That's correct. The
Under
government
other
knew nothing about
circumstances.
and probably would not have found out about.
Very interesting. And Bob, touch a little bit upon this privileged information because, you know, the panel this morning had said, you know, yeah, give us everything and we want certain things but not other things, and I think your panel disagreed with some of those propositions. So tell us where the line should be drawn in your opinion.
Yeah, it's one of the most controversial aspects of the government's effort to get corporations to cooperate in the fight against crime is the waiver of the attorney-client privilege. And the government wants that waiver and wants to be able to get from corporate counsel the results of their own investigation, including privileged communications. And the Department of Justice draws a distinction, which is a helpful one, between core attorney work product, your legal opinions about the case, how you're going to defend the case, those sorts of issues, and fact-based information, so a fact-based memo of interview. And what the government says is that you should give us the fact-based interview. We don't care about your legal strategy. We think you should protect that. So that's laudable that they take that position. But the problem is, in the corporate setting, what you frequently have, in addition to the prosecutors and regulators, you have the risk and frequently the reality of private civil litigation. And the law in our country on the waiver of the attorney-client privilege is a very broad subject matter-based principle, so that if corporate counsel turns over the memo of interview that the Department of Justice wants, dealing with transaction X, there is an argument, we would fight against this, but there is an argument that can be made by the plaintiff's bar that all memos dealing with that same subject matter, transaction X, are waived. And that's a very, very troubling concept for companies and for anyone dealing with the Department of Justice, quite frankly, in this context.
Wow. Very interesting legal argument for sure. Bob, thank you so much for taking the time to chat with us this afternoon. We sincerely appreciate it. The panel was very informative, so we appreciate you taking the time.
Thank you very much.
Thank
Good to
you.
meet you.
You as well.